Good morning, everybody. I'd like to offer a very warm welcome to everybody who's joining today's seminar, the Care Act Through COVID, which is going to look at the legal changes to the Care Act introduced in response to the coronavirus. Thank you very much to you all for taking the time to join me in what I know is a very busy time for you all. Owen Mitchell are running a number of seminars throughout this time of crisis, bringing together our clients, communities and colleagues. My name is Ollie Studdert. I'm a partner in the Public Law and Human Rights Department, specialising in social care and court of protection matters. Thank you to those of you who have already submitted questions this morning. If you'd like to ask questions throughout this session, then please submit them via the question and answer function on your screen, and I'll do my best to answer them at the end of the session. We are going to be recording this virtual event, and we'll be able to send you a copy of the recording out after the seminar. If I could have the next slide, please, James. The Care Act Easements guidance for local authorities came into force at the beginning of last month. It was introduced to enable local authorities to use a number of Care Act easements under the Coronavirus Act 2020, and I'll go on through the seminar to talk about what those changes are. It's important to note that the guidance is statutory guidance, which has been published pursuant to paragraph 18 of Schedule 12 of the Coronavirus Act, which means that local authorities are required to have regard to it. Next slide, please, James. So why were the easements introduced? I'll read from the guidance here because I think it gives it good context. The guidance states that local authorities and care providers are already facing rapidly growing pressures as more people need support because unpaid carers are unwell or unable to reach them, and as care workers are having to self-isolate or unable to work for other reasons. The government has put in place a range of measures to help the care system manage these pressures. The local authorities should do everything they can to continue meeting their existing duties prior to the Coronavirus Act provisions coming into force. In the event that they're unable to do so, it is essential that they're able to streamline the present assessment arrangements and prioritise care so that the most urgent and acute needs are met. The powers in the Act enable them to prioritise more effectively where necessary than would be possible under the Care Act prior to its amendment. They're time limited and they're to be used as narrowly as possible. So in other words, the government anticipates that because of the coronavirus, there'll be people who are unable to receive support from their normal carers, which could place additional pressures on local authorities, and because of this, local authorities are authorised to operate in different ways. The next slide, please, James. What are the key changes? Well, under Section 9 of the Care Act, local authorities ordinarily have a duty to assess whether an adult has care and support needs, and if they do, then to identify what those needs are. Under Section 10 of the Care Act, the local authority also has a duty to identify what support needs a carer may have. These requirements can be removed under the new guidance, although where a request for support is made, then local authorities are still expected to respond as soon as possible and within a timeframe that won't jeopardise an individual's human rights. The local authority would also need to consider the needs and wishes of the people needing care and their family and their carers and make an assessment of what care needs to be provided. The next key change is the removal of a duty to carry out financial assessments. Section 17 of the Care Act requires local authorities to carry out an assessment of an adult's financial resources and to identify what amount, if any, the adult would be likely to pay towards their care. However, under the new guidance, the local authority will have powers to charge people retrospectively, as long as they give reasonable information in advance of this and carry out a financial assessment at a later time. The third change is that there is no longer a requirement to prepare or review care and support plans, although local authorities are still expected to carry out proportionate person-centred plannings. Under sections 18 and 20 of the Care Act, local authorities have a duty to meet an adult's assessed needs. They also have a duty to meet a carer's need for support. The guidance amends this to an expectation that proportionate person-centred planning is undertaken, which provides sufficient information to all concerned. There is an exception to this, which is where a failure to provide care and support would be a breach of the person's human rights, and I'll go on to talk about that a little bit more shortly. The next change is that duties to meet eligible care and support needs are replaced with a power. So what this means is previously under the Care Act they must meet the needs, whereas now they simply have a power to meet the needs of the individual. Where local authorities are unable to continue to meet needs, this change allows them to prioritise what they consider to be the most pressing needs and to temporarily delay or reduce other care provision. It is of course the case that when the guidance ceases and the Care Act resumes, that there will be a requirement for the local authorities to continue to meet all of the needs as per previously. Additional change brought about by the guidance relates to children transitioning to adult social care under sections 58 and 59 of the Care Act, and that duty has been temporarily relieved. The next slide, please, James. Thank you. Are the easements being used? Well, the guidance is clear that local authorities will still be expected to consider people's needs, and that easements will only apply when it's no longer possible for them to carry out their pre-amendment Care Act duties in full. The examples that I'm going to give in relation to potential breaches of human rights: Article 2 of the Convention, the right to life; Article 3, freedom from torture and inhuman and degrading treatment; Article 5 relating to liberty; and Article 8, right to family and private life. There is still an expectation that local authorities should carry out an assessment of people's social care and support needs, to make a written record of their assessment to consider whether or not there has been a breach or might be a breach of their human rights. The next slide, please, James. The guidance envisages that there will be 4 stages, and I'm going to go through what the guidance says about each of those 4 stages, because I think it's really helpful to understand the distinctions. The first stage is operating under the Pre-Amendment Care Act, so business as usual, and local authorities are expected to continue at this stage for as long as is feasible. Stage 2 is applying flexibilities under the Care Act, and this is a decision for individual service type to prioritise short-term allocation of care and support using the flexibilities that exist within the Care Act. So that's not yet applying the easements. The process, as set out in the guidance for stage 2, is where COVID-19 related absence means service types need to be changed, delayed or cancelled short term within that service type, for example, care homes or supported living, the relevant senior manager or assistant director should consult the principal social worker and should detail the reason the decision needs to be taken, the impact of the decision on the people who will ordinarily use the service, impact of the decision on families and carers of people who ordinarily use the service, and possible alternative sources of care and support and the likelihood of this being available. Where the principal social worker is satisfied, this position can then be presented to the Director of Adult Social Services for a final decision about moving into stage 2. So a decision still does need to be made in order to move to stage 2. It's important to note that all other services may well continue to deliver their services as business as usual. So on to stage 3, which is where local authorities are streamlining their services under the easements, and a decision to operate under the Care Act easements is taken as laid out by the Coronavirus Act. The guidance states that the Care Act easements allow local authorities to cease formal Care Act assessments, applications of eligibility and reviews. However, there is an expectation in the Act that local authorities will do everything they can to continue to meet the need as was originally set out in the Care Act. So that's very important to note. Where the impact of the pandemic is making this unachievable or untenable, the guidance says, local authorities will need to make the decision to cease carrying out those eased Care Act functions and move to a position of proportionate assessment and planning. The relevant assistant director or senior manager will need to consult with the principal social worker and be clear about the reason the decision needs to be taken, the impact of the decision on the people who ordinarily use the service, and impact of the decision on families and carers of people who ordinarily use the service. If the principal social worker is satisfied that the Care Act easement needs to be enacted, a meeting of the Senior Management Board should be called for a final decision. The decision should also consider and be informed by a conversation with local NHS leadership. The Director of Adult Social Services and the Principal Social Worker should ensure that their lead member has been involved and briefed as part of this decision-making process. And very importantly, the Department for Health and Social Care should be notified. The fourth stage is prioritisation under Care Act easements, whereby the whole system is prioritising care and support. And the guidance states here that where local authorities need to make decisions about changing support for people, they should consider and allocate capacity across the whole of adult social care. This may mean allocating resource from some service types that may not be under pressure to support those that are. An example might be where a local authority is faced with a decision about reducing personal care for one person so that another gets the help that they need to eat. In this situation, the relevant assistant director or senior manager should consult the principal social worker. They should detail the reason the decision needs to be taken, the impact of the decision on the people who ordinarily use the service, the impact of the decision on families and carers or people who ordinarily use the service, possible alternative sources of care and support, and the likelihood of this being available. If a local authority decides it may need to move to stage 4, the principal social worker should call an emergency decision meeting of the Director Adult Social Services, where a decision about whether or how to prioritise care across adult social care will need to be made. Sufficient care and support will have to remain in place at all times in order to ensure the convention rights of all those in need of care and support and of carers are respected. The Director of Adult Social Services and the Principal Social Worker must ensure that their lead member has been involved and briefed as part of the decision-making process, and again, importantly, the Department for Health and Social Care should be notified. And also, extremely importantly, any decisions taken to prioritise or reduce support should be reviewed every 2 weeks with the Principal Social Worker, and full service should be restored as soon as is reasonably possible. If we could have the next slide, please, James. So the requirements to report that I just mentioned, local authorities applying the easements under stages 3 or 4 are required to report any decision to do so to the Department for Health and Social Care. In April of this year, 8 local authorities had notified the Department of Health and Social Care that they were going to be operating under the new guidance. These were Sunderland, Warwickshire, Staffordshire, Birmingham, Derbyshire, Coventry, Solihull and Middlesbrough. Middlesbrough said that they were going to be operating under the easements for a single week, but then ceased doing so and returned to Care Act duties. The DHSC had indicated they were going to be publishing a full list online of those authorities who were acting under the easements, and it was reported by the CQC last week that Birmingham and Sunderland had both ceased operating under the easements. I'm not aware, I haven't seen any specific reasons given, but clearly it's good news, and clearly they no longer felt that it was necessary for them to be operating under the easements. How are councils using the easements? Most of the authorities I've just referred to appear to be operating under stage 3 of the easements by not carrying out assessments, reviews or care and support planning. Birmingham had been streamlining processes under stage 3 whilst continuing to provide care and support to people with eligible needs. They did say at the time that this involved not providing hard copies of assessments or care and support plans to people and limiting choices of providers, but as I've just mentioned, they're no longer operating under the easements. Sunderland had also said they were operating under stage 3, but as of the beginning of May they hadn't taken any action under the easements, but were looking to use them as part of prudent planning measures. It may be that following a further review they concluded that they didn't need to rely on them, and this is why they have ceased. Coventry had said that it was carrying out less detailed assessments because of the need to carry out virtually all of them remotely, doing less detailed care and support plans and not undertaking scheduled reviews. It said its workforce had not been depleted, nor had demand increased to the extent that it needed to enact stage 4, but if it had to, it would contact people with lower level needs to see what the impact of a reduction in care would be. Staffordshire said the only action it had taken so far under the easements was deferring a very small number of Care Act assessments, and that if it had to enact stage 4, this would be decided on a case-by-case basis, taking into account all of the risks. Warwickshire said it had developed a streamlined assessment and support planning process for practitioners to use when they cannot use normal processes, and it suspended some scheduled reviews because of the barriers to seeing people due to social distancing. It's not clear whether any consideration had been given to conducting reviews virtually. Derbyshire had suggested that it was planning to operate at stage 4 in order to focus its resources on meeting the most serious and urgent care needs. It said people with lower level needs and support from family, friends or the community may be affected by changes to the length, time or frequency of care home services, as well as the suspension of certain services and changes to care workers or providers. So a range of different responses there from different authorities who were operating under the easements or planning on potentially operating under the easements. The next slide, please, James. Before a local authority notifies the Department for Health and Social Care, they need to consider whether or not it is absolutely necessary. So it needs to consider whether it can fully meet its care duties under the Care Act and whether trying to do so may lead to some urgent or acute needs or services not being met. The guidance is clear that prior to applying any easements, the Director of Social Care must decide that the workforce is significantly depleted or demand on social care increased to an extent that it is no longer reasonably practicable for it to comply with its Care Act duties as they stand prior to the amendments by the Coronavirus Act, and that to continue to do so, or continue to try and do so, is likely to result in urgent or acute needs not being met, potentially risking life, and that's set out in section 6 of the guidance. The guidance also makes clear that any decision to follow the guidance should be made in consultation with other relevant bodies and people in such a way that changes are only made where truly necessary. The guidance sets out a number of steps that should be taken, and any decision should be recorded and should demonstrate, first, the nature of the changes to demand or the workforce, 2, the steps that have been taken to mitigate against the need for this to happen, 3, the expected impact of the measures taken, 4, how the changes will help to avoid breaches of people's human rights at a population level, 5, the individuals involved in the decision-making process, and 6, the point at which this decision will be reviewed again. As I've mentioned, the next stage is for a senior management meeting to take place for a final decision, and if the local authority proceed, then they need to report to the DHSC, and they also need to inform providers, service users, carers, and as of last week, a change that's been made, also need to inform local MPs. The local authority then needs to go on to consider whether an act on the easements might breach the individual's rights under the ECHR, and it will also need to have regard to the ethical framework on adult social care. James, could I have the next slide, please? The framework was published on the 19th of March, so prior to the guidance. It was introduced in order to help local authorities with their decision making under difficult pressures and in limited timeframes. It's intended to provide support to ongoing response planning and decision making to ensure that ample consideration was given to a series of ethical values and principles when organising and delivering social care for adults. It states that in all instances, respect and reasonableness should be used as the fundamental underpinning principles which guide planning and support judgment. The framework is intended to be used as a checklist to ensure ethical considerations are taken into account, and although it's not exhaustive, there are 8 principles listed, and these are respect, which requires the local authority to recognise that every person and their human rights, personal choices, safety and dignity matters. Reasonableness, that is ensuring that decisions are rational, fair, practical and grounded in appropriate processes, available evidence and a clear justification. Minimising harm, striving to reduce the amount of physical, psychological and social and economic harm that the outbreak might cause to individuals and communities. In turn, this involves ensuring that individuals, organisations and society as a whole cope with and recover from it to the best of their ability. Inclusiveness, ensuring that people are given a fair opportunity to understand solutions, being included in decisions that affect them and offer their views and challenge. In turn, decisions and actions should aim to minimise inequalities as much as possible. The 5th value is accountability, that is holding people and ourselves to account for how and which decisions are made. In turn, this requires being transparent about why decisions are being made and who is responsible for making and communicating those decisions. The 6th value is flexibility, being responsive, able and willing to adapt when faced with change or new circumstances. It's vital this principle is applied to the health and care workforce and wider sector to facilitate agile and collaborative working. The 7th is proportionality, providing support that is proportional to needs and abilities of people, communities and staff, and the benefits and risks that are identified through decision-making processes. And the final value, although as I say they are not exhaustive, community, commitment to get through the outbreak together by supporting one another and strengthening our communities to the best of our abilities. The next slide, please, James. Does the does the guidance only impact new requests for support? The simple answer is no. Local authorities can apply easements to care packages which were in place prior to the guidance coming into force, likely to be those under stage 4 of the 4 stages which I've set out earlier on. The steps I've mentioned would still need to be applied, and whilst I anticipate that there could be some reductions in existing care plans, especially those that are currently up for review, I would expect most of the easements to be applied relating to new requests, and I think that's really going to be borne out if we are able to get figures of where the easements are being used. The next slide, please, James. It's a relief to see that there are some things that are not changed by the guidance. Section 4 of the guidance is where it confirms that a number of key duties set out in the Care Act 2014 remain in place. First is the duty to promote well-being and duties relating to safeguarding of adults at risk. That remains in place. Safeguarding guidance is set out at more detail at Annex D of the guidance, which I'm not going to go into, other than to say that it states that it is vital that local authorities continue to offer the same level of safeguarding oversight into application of Section 42. There's also some recognition within the guidance that there may be more safeguarding issues arising as a result of the COVID crisis, so clearly that's why they have felt it necessary not to make any amendments there. The duties in relation to the Mental Capacity Act 2005 relating to the deprivation of liberty safeguards remain in place. The entitlement to have an advocate through the decision-making process remains. Given that some of the decisions may well be made under the guidance are going to affect people's support moving forward, it may well be that some individuals become eligible for independent advocacy who wouldn't have done otherwise. There was a very interesting article, I think last week, by Kate Mercer on communitycare.co.uk, in which she cited examples of advocates who had witnessed incorrect information being shared with individuals. One example that she gives was where social workers were informing individuals that they were not entitled to an assessment because of the COVID-19 crisis. This is despite the fact that the local authority where they lived had not implemented the Care Act easements, and so was therefore still operating under the pre-amendment Care Act, and absolutely did have a duty to carry out an assessment. And the article also goes on to give examples of advocates who have been correcting misinformation, where care home residents have been told that they cannot go out, or where those detained under the Mental Health Act have been told that they cannot have Section 17 leave. But clearly that's wrong even where the easements are in force. The local authority duties under the Equality Act also remain, so there continues to be a requirement for local authorities to make reasonable adjustments, and the public sector equality duties towards people with protected characteristics still apply. The next slide, please, James. Might there be any possible challenges to the easements? There's already one of the local authorities has received pre-action correspondence in respect of their use of the easements, and I understand that a response is due this week. So it'll be interesting to see what, if any, fallout there is from that. If a local authority is acting under the guidance, even just in respect of one aspect of the guidance, and it hasn't notified the Department for Health and Social Care, is acting unlawfully. It's apparent from the Kate Mercer examples that I've given that it is at best a misunderstanding in some local authorities as to what they are allowed to do under the guidance, and I wouldn't be surprised to find out that a number of authorities are operating under the easements when they haven't actually notified the department. I think it's also likely that there are excuses being used in a number of different areas where people are being simply having services withdrawn without this being properly informed to them, and they're not being told any reasons why, and they're certainly not being told that whether the local authorities are in fact operating under the easements. Day centres are closing, respite centres are closing, and it's highly likely that where this is happening, service users are going to have unmet needs, and it's not clear what is being done by local authorities to meet those needs in those cases. If you're aware of any authorities who happen to be acting in such a way, I think the first thing that should be done is raise it with them immediately. Speak to the social worker concerned. It may well be that the social worker themselves has concerns about the way in which they are having to operate, and it may be that this is something they could raise internally with their manager or with a principal social worker. If the authority maintains that they are entitled to act in such a way and you think that's wrong, then of course you can seek legal advice, or the individual can seek legal advice. You have seen that where a local authority has notified the department, they can't simply disregard their duties under the Care Act simply because they have said that the guidance is in force and they are doing this. They have to keep a written record setting out the reasons why they have taken this decision. They need to keep the decision under review, and they then need to take further steps before they can follow the guidance on an individual case basis. Although there's no requirement for a local authority acting under the easements to carry out an assessment in the same way it would have done previously, subject of course to those caveats I've just mentioned, the authority must assess whether or not the failure to provide support would breach a person's human rights. Decisions with reasons should be put in writing. Examples of what constitutes a breach would need to be considered on an individual by individual basis. This might include a failure to provide support and assistance with accessing suitable accommodation or access to food. It might be limiting contact between family members. That may not be face to face. There's a clear acceptance that that may not be appropriate, but there are other methods that can be used, either virtual or people being driven to places where they can now socially distance appropriately with a single family member, and also to make sure that local authorities are not acting in a way that results in a person being unlawfully deprived of their liberty. If it can be shown that a local authority has failed to follow the ethical framework, this could also give rise to a challenge. Further, any decision which might result in the local authority breaching its duties under the Equality Act would give rise to a challenge. If decisions have been made and if a person's been denied an assessment or support and they've not been involved in this decision, they've not had this decision communicated to them throughout the decision-making process, and or they've been denied an opportunity to have an independent advocate where they should have been, this would also give rise to a potential challenge. If I could have the next slide, please, James. Thank you. This seminar has focused on the Care Act as opposed to the changes affecting children, but I did want to mention them in brief. There have been a number of changes affected by the Coronavirus Act in respect of children. This guidance, as I've already mentioned, removes the duty on local authorities to undertake assessments of children transitioning to adult social care. In my experience, local authorities' engagement with this duty historically has been poor in any event, even without these easements being in place. However, it is extremely important support around transition, and lots of young people moving into adult services find delays in services being provided, and will often find a totally different provider coming into place. And this is something that needs to be very carefully planned for and prepared for, because failure to do so can have dire consequences. So I think that we do need to be monitoring these situations and making sure that where a young person does have needs, and those needs are going to be continuing after the age of 18, local authorities are pressed as much as possible to make sure that they are carrying out assessments, because failure to do so, I do still think, could give rise to a possible breach. The special educational needs and disability Coronavirus Amendment Regulations 2020 came into force on the 1st of May. These make amendments to 4 sets of regulations which set out statutory timeframes which apply to local authorities and CCGs, and are essentially linked to the processes around EHCP's needs assessments and plans. Also, in relation to special educational needs, the Secretary of State for Education issued a notice under Section 42 of the Children and Families Act on the 28th of April, and that substitutes the needs for local authorities or CCGs to secure or arrange the provisions set out in EHCPs to a requirement for the authority to simply use its reasonable endeavours. That notice is enforced for a period of a single month at present, but can be extended. The government has also recently issued amended guidance for children's social care services, and I don't want to draw a direct comparison with the easements guidance, but there are definitely similarities between the two. It is important to note, however, that the guidance on children's social care services is non-statutory guidance. In respect of looked after children and those within the care system or entering the care system, the Adoption and Children Coronavirus Amendment Regulations 2020 affect children in care, with a number of important safeguards having been removed, again temporarily, although there is some concern that a number of the changes made are changes which the government have been trying to introduce for a number of years. I know that's a concern that some people have also raised around the easements guidance, although the government have been very clear in saying that this is temporary guidance and this is something which is only going to be in force as long as the coronavirus crisis continues. If you could have the next slide, please, James. What should we be looking out for in the coming weeks, or what might we expect? Although I'm not aware of any additional local authorities having given a clear indication they will be operating under the easements, I understand that Wolverhampton have been carrying out a mini consultation which closed yesterday, and I think it was North Yorkshire have also been suggesting that they might be looking at moving towards following the guidance if they need to. It is encouraging, I suppose, that no new local authorities have moved to operate under the easements in the last month or so. That may be an indication that most local authorities don't feel it's necessary to take such steps, although I do think it is possible that as the COVID-19 crisis continues, that more local authorities may seek to reduce specific support in certain areas. It's important we're alive to such changes, and where local authorities are operating under the guidance, that they're following the necessary steps and acting in a lawful manner. It is, of course, possible, and my hope is that as restrictions are lifted and the threat of the virus reduces, we'll see more authorities, such as we've seen, and I mentioned earlier, the two authorities ceasing to operate under the guidance. Given the relatively low number of authorities who have decided to rely on the guidance, and indeed some directors of social services have openly spoken out against the guidance, I would hope that we won't see any further changes by the government to the law in respect of local authorities' duties under the Care Act. I think it's clear from the examples that I've given earlier that some support workers and social workers are likely to be misinterpreting the guidance, and it's of course possible that where some local authorities have informal policies under which they're operating the easements, that where this is the case, these authorities need to be held to account. One area that I think we need to be particularly alert to is unlawful deprivations of liberty. So much so that on the 15th of May, the Vice President of the Court of Protection, Mr. Justice Hayden, wrote to the Directors of Adult Social Services to highlight that, now I'll quote from him, "The deprivation of the liberty of any individual in a democratic society holding fast to the rule of law will always require appropriate authorisation. Nothing has changed. The Mental Capacity Act 2005, the Court of Protection rules, and the fundamental rights and freedoms which underpin them are indispensable safeguards to the frail and the vulnerable." So very strong words and very clear words there from the Vice President. I have heard of a number of instances of individuals with care needs who have been moved to a care home for respite, for example, and they're no longer being allowed to leave the home, to return home, despite there being no lawful reason for them to be deprived of their liberty. Could I have the next slide, please, James? Owen Mitchell are producing another seminar which may be of interest to a number of you in a couple of weeks. I think it's the 6th of June. My colleagues Caroline Barrett and Emma Earnshaw are going to be giving a seminar on COVID-19 and what it means for advocates working in the Court of Protection, and that will be covering the Coronavirus Act, do not attempt CPR, emergency, MCA and deprivation of liberty safeguards guidance, and working in the Court of Protection during the pandemic. I hope that you found today's seminar useful. Owen Mitchell has a website, a web page which is dedicated to advice specific to matters which arise from the coronavirus across a range of legal issues, as well as containing some very important information. It also contains a number of helpful links, so please do feel free to take a look and see if there are any articles or other seminars which may be of interest. We will also be posting a feedback link in the question and answers section of this meeting, so please do click on that. It's always valuable to get feedback. And if anybody has any questions and answers, I would now be happy to answer those, so please type away in the box. I know we've had a question in already, which is what happens if social workers visit the home without PPE? Well, clearly we've seen a large increase in care homes, a very concerning increase of coronavirus in care homes, and of course social workers should be using PPE when they are visiting. I don't have statistics in terms of how often social workers are now using virtual meetings as opposed to the face-to-face meetings, and there will be cases where that's appropriate. There will be cases where face-to-face meetings do need to take place, and of course social workers should be wearing PPE, and I believe that most care homes are robustly enforcing this. If a social worker is not wanting to wear PPE or is not able to wear PPE because it's not available, I think we need to be finding out the full reasons for this. and getting an understanding of it, because it may well be that there is a very serious risk to the residents in the home if there's somebody coming in from the outside. And it's something that I think that homes need to be working together with social services in order to try to avoid. I know that some people have been asking about people in care homes and being able to leave the homes and visiting. That's clearly a very important issue for many residents in care homes, and I think that a lot of people are being taken out, are getting out. If they're not, then this is something that does need to be looked at, because people have, of course, got an absolute right to be able to leave the care home, subject to some authorization restrictions, but if those aren't in place, then they should be able to go out and about, and it's a matter of working with the home to see how this can be best achieved. And I know one recent example was somebody required 2-to-1 care, and the home had initially said that 2-to-1 was simply not going to be available, and they believed it would be a breach of the social distancing measures. But when they were asked to reflect on that, they considered that failure to take the individual out would be a breach of the individual's human rights, and there were ways in which they could do this. They were able to find a place where the individual was able to safely isolate away from other people with the 2-to-1 care, and that continued, was successful, and carries on now. We're just seeing if there are any other questions coming in. Can care homes and mental health hospitals have blanket bans on visitors even when they are COVID free? They would still need to look at individuals on a case-by-case basis. So a blanket ban, I would say no. There may be very good reasons why visitors should not be going in, but there may be very good reasons why individuals absolutely needs to have a visit. It may be that there are other ways of doing this. So, for example, there have been cases where people have been taken from the care home to a courtyard to have visits taking place there. There have been visits that have been taking place on ground floors through windows from an acceptable distance. So there are other ways of getting around this. It would need to be looked at on a case-by-case basis, but I certainly don't think that a blanket ban itself would be lawful. I'll just wait a couple of moments to see if any other questions come through. Okay, I think in the absence of any other questions, we'll wrap up there, but thank you very much for your time. If anybody does have any specific questions that they'd like to contact me directly about following the seminar, please feel free to contact me, and we've got the email address here on the screen. If you email them, they will make sure that it comes on to me as well. Thank you very much for your time this morning. Have a good week.